Hi everyone, I'm Vanzi, and before we get started, I know this has been said a lot today, but I can't say enough about the New Mexico Law Review and especially Chanel Daniels for putting this program together. For those of us who met with the Law Review early on, this has been a long time coming, and if anybody needs a law clerk or wants to hire someone who is more dogged than anybody I know and can overcome any obstacle, get Chanel's resume. You need to hire her. Yeah. All right, so the panel today is about looking forward, and we have 3 practitioners here. I was going to say thank you for staying to the end, but I realized y'all are all staying for the ethics credit. You're not staying for it. So Phil Sleaze will be on after us. I'm going to introduce everyone first. To my immediate right is Cody Rogers. Cody's been practicing in New Mexico state and federal courts since 2006. She represents clients in all stages of litigation, trials, and appeals, and she primarily represents state and local governments and government agencies, as well as public employees and elected officials in civil rights, employment, and negligence claims. She's a past president of the New Mexico Defense Lawyers Association and a co-chair of its annual Civil Rights CLE program. For reasons that become less clear every year, these are Cody's words, not mine, she is a lifelong Denver Broncos fan.
Yeah! You feel my pain. I do!
And then in the middle is Michelle Garcia. Michelle is a graduate of Loyola University and who is admitted to the New Mexico Bar, Navajo Nation Bar, the State Bar of Louisiana, the Pueblo of Milwaukee, and the Federal District Court of New Mexico. After graduating from law school, Michelle worked as a prosecutor and a law clerk for the state of New Mexico. She then joined New Mexico Legal Aid in 2018 and became the managing attorney for Safe BU to BU, New Mexico's LGBTQ+ legal access program for rural and indigenous communities, and also serves as deputy director for New Mexico Legal Aid. She works in the areas of civil rights, violence, rural accessibility, and LGBTQ discrimination. Little known fact about Michelle, because she looks very serious, she's in a punk rock band. And she would like you to know that she went to law school in Louisiana, where contracts don't require consideration. And then to my far right is Alexandra Freedman Smith. Alexandra Smith is a native of New Mexico who attended UNM School of Law, and she's been practicing for 21 years. She was the legal director of the ACLU of New Mexico and now has her own civil rights practice where she represents plaintiffs. As I think Mark mentioned earlier, Alexandra was the staff attorney for the commission before the legislature for the enactment of the act. She probably knows more about civil rights, what has happened around the country, statistics, than any of us or all of us in this room combined. So I asked her to give me a little fun fact, and she said, Alexandra's no fun. That's all she does is work. So with that, because this is looking forward, all 3 of these practitioners, Alexandra, Cody, and Michelle, all are actively engaged in practicing in civil rights. So I thought if each of them could talk a little bit about their practices and the types of cases they're seeing, that would be a good starting point. And we may stop a little bit early because it seems like this crowd has a lot of questions, and these are the people that can probably answer them. So, who wants to go first? Does the defense lawyer want to go first?
Sure. I never get to go first, so this will be new. So as far as government liability, which is sort of generally what I would call my practice, is concerned, I have a fairly broad practice. So I don't specialize in any particular type of government liability case. So I have police shootings, I have pursuits, I have car accidents, I have slip and fall on a manhole cover, I have employment law in the public sector. I have a kind of a wide variety of cases. A lot of what I do is federal litigation based on 1983 claims and sometimes 1981 claims, depending on the context. and then the new hotness, which is the Civil Rights Act. I will say that as it was a little, not strange, but it's just a different perspective that Luis Robles was expressing this morning about the kind of cases he's seeing in his civil rights practice versus what I'm seeing. Because he was saying, well, he's seeing these Civil Rights Act cases that are brought by experienced practitioners that we've all litigated against for years and years in federal court. And I am not. Sometimes I am. I still have cases against people who I would consider very experienced in the civil rights arena. And I will say that, and this is very biased on my part, but I think civil rights is a difficult and challenging area of law. I don't think it's something you can just kind of bounce in and out of or dabble in or kind of practice as a side area. I think it is an intellectually challenging, ever-evolving, complex area of law that requires a lot of knowledge and experience. And it's hard to learn, and you have to stay on the cutting edge, especially in the qualified immunity context, because you have to know what the clearly established law is. And so I think that it is a niche practice area, and there aren't a lot of us. I mean, I know pretty much everybody on both sides of this everywhere I go. It's a small batch of us that kind of handle those cases. And I thought when the Civil Rights Act passed, okay, it's going to be the same people, we're just going to be dealing with a different statute. That has not been my experience. I have basically got two tiers of cases now, I would say. And the first tier are the cases that would have and still do go to federal court. These are your police shootings, your wrongful deaths, your sort of bigger value cases, at least in terms of a potential settlement or a verdict. And those were always going to go to federal court as 1983 claims, and they still go to federal court as 1983 claims, just with a Civil Rights Act claim also pled. And then we have the other cases. And the other cases are primarily brought by folks who are not are not people I have run across before in the civil rights context that I would affectionately refer to as dabblers. People who maybe had a criminal case and they beat the criminal charges on a bad stop or a bad search, and so now they decide, well, if the judge suppressed the evidence, maybe I can win a civil rights claim. And so then they file under the Civil Rights Act, and those cases are all in state court. So I think it's almost kind of in my practice developed into two different tiers of cases. And the approach to them is very different. The sort of vibe to them is very different because, again, in tier one, I know all these people. I've worked with them. I've settled cases with them. I've tried cases against them. I don't necessarily know all these folks. And because the law is new, that has a whole set of challenges with it that I maybe didn't anticipate when the law passed.
Can I just ask a question? What types of claims are you seeing under the Civil Rights Act?
So tier one is what we would have always seen. They're just pled, so if it's let's say it's a police shooting, there's a federal Fourth Amendment claim brought under 1983, and then there's a state analog to that brought under the Civil Rights Act. It's pled just like you would expect it to be pled, textbook. There's no 12b6 for me there. The tier two claims focus a lot more on pieces of the Constitution that I don't necessarily think are going to be able to be vindicated under the New Mexico Civil Rights Act, like the inalienable rights, the right to happiness, the right to pursue happiness, the right to liberty and not in the confinement context, the right to just sort of an overall right to pursue happiness and to
what was the happiness that was taken away from you?
Well, that's kind of the question, right? So you look at these when you get them, and I have one right now. It's a wrongful death case. The claim is a wrongful death claim. Someone got shot and died, and it's pled as a civil rights and a negligence claim. And the negligence claim is pretty straightforward. The Civil Rights Act claim is, well, this person had a right to life, liberty, and the pursuit of happiness. Yes, agreed, but we're not talking about a law enforcement entity. We're not talking about a jail situation or a confinement situation. So we're not in Fourth Amendment territory or Eighth Amendment territory. so where are we? Are we looking at a substantive due process claim that this is really a danger creation theory, or where are we? And so a big part of the challenge with tier 2 is just figuring out what is the right. Because once I know that, then I can say, all right, am I going to look at it under the interstitial approach and see if I can kind of figure out a box for this? Or am I going to go to the court with something a little more generic and say, Judge, what this appears to be is just a negligence claim in the guise of a Civil Rights Act claim, which is a huge concern for the defense of the bar. So that's a huge part of figuring out what's going on, is what box do I put this in, what is the claim that's being made, and how do I address it?
Thank you. Michelle?
So working for New Mexico Legal Aid, we do encounter dabblers. We handle, I think this year we're on track for 7,800 cases. And, you know, if you think about that as a giant funnel, there's a tiny percentage of those cases where people come to us because they are interested in pursuing a civil rights claim. I would agree with Cody that New Mexico, I believe historically, has not had a huge number of practitioners in this area. So if you're a low-income person whose deprivation of rights did not involve wrongful death or police shooting, kind of those headline-type cases, chances are they're calling legal aid or our colleagues at the ACLU or the Center on Poverty, because there aren't many other options that are accessible to this population. A lot of what our clients tend to be interested in are actually not monetary damages. So I was very interested to hear some of the dialogue in the last discussion, because what our LGBT Civil Rights Project has primarily focused on and filed cases involving the New Mexico Civil Rights Act tend to be involving trans women of color who want to change a process that affects an entire population, or queer children in school and public accommodation type settings. You know, think of public education or public libraries, places where queer children are maybe butting up against you know, some Title IX and Title VII type issues. And so the type of cases that we are seeing, in part because we don't practice really in that kind of criminal overlap world, I think are quite different from some of what I've heard here today. Although I did share with Judge Vanzi that I am personally aware of at least 2 fire departments that have called us because they can't get insurance.
So have you actually filed cases? Do you have pending cases in court now?
We do, and you know, I was very interested to hear, I forget, I think it was a gentleman over here, talk about the application of 1983 in New Mexico, because in my view, the defense bar here has been very effective at applying federal case law to New Mexico state claims, and all the way down, including discovery matters. And I think that until we get more clarification from the 10th Circuit on where this boundary exists, I believe that we're still seeing a lot of cases that are being decided under federal precedent instead of attempting to define what New Mexico state-specific looks like.
Thank you. You want to come back to that, because I think that's a really big issue to discuss. Alex?
So I can only talk about the cases that I have and the cases that I know that you know, colleagues that they have. And so yeah, I mean, definitely people are bringing bringing New Mexico Civil Rights Act cases, but they're not always exclusively just under the New Mexico Civil Rights Act. People are still bringing claims under the New Mexico Tort Claims Act and also 1983, and sometimes all 3 together, depending on where they want to be, or depending on whether it's a case that where the cap under the New Mexico Civil Rights Act, if it's a bigger case than that, they might still want to bring their 1983 claim to be in federal court as well. But it does add another claim, and I can imagine certain cases where that would be the only claim, but a lot of times you're wanting to bring all the claims that you possibly can for your client. In case something goes awry, you want to make sure that you've got a backstop, or that you have brought the other thing, because you know, you never know. And then also for those who do employment law, and I do some employment law, this hasn't had a huge effect because it doesn't apply in that setting, so you're still where you were, which you know, definitely narrows. So I think some of the rhetoric around how broad this would be and how it would be everything, you know, there are certain things that have hemmed that in, and I think that is one of those restrictions.
So when you talk about where you file your claims, right? The Civil Rights Act says you file your claim in any district court in New Mexico. The Tort Claims Act says you file it in the county where the harm took place. In 1983, there's concurrent jurisdiction. So you could conceivably file 3 separate claims in 3 separate courts.
I guess somebody could. I would not do that. That seems like it'd be hard. So to me, if I had a Tort Claims Act claim and a Civil Rights Act claim, I would file it in the place where the Tort Claims Act claim was, where you have to under that. But that could be a consideration for some of why they wouldn't file it under the Tort Claims, why they wouldn't bring a Tort Claims Act claim if they didn't want to be in that particular place. Maybe they would bring it somewhere. Maybe they wouldn't bring that claim.
And that's why I'm asking that, because there are some parts of the state you may not want to have a civil rights claim being brought, when you could maybe bring it in Santa Fe or in Albuquerque. So do you think about that when you're, for the two of the plaintiffs who are filing these lawsuits, do you think about where you're going to file a civil rights claim?
Yeah, absolutely, absolutely. And in some cases, it might be better to be in federal court. I mean, it just depends. But absolutely, you want to think about where you're going to be, and that would affect where you're going to file your claim. But for some cases, you may be concerned that somebody could interpret it as just being a negligence claim, and then you want to have your tort claims as a backstop if that argument's going to fly, which, but hopefully, that would not be the case. But you do want to have a backstop on some of that, so it would depend. But yeah, I think that you're always thinking about where you want to be and the best venue to be in, which is sometimes state court, but not always.
I think I would add that state court is cheaper, which for our population is an important consideration, and that some of the types of discrimination that we see are alive and well at a level in rural locations that are very different than our urban centers in New Mexico.
And I was going to ask you about that, particularly the population you serve. Do you tend to file your claims more in one place than another?
Yes, so we have filed cases in rural jurisdictions and also in our urban centers, and what we have found is that the concerns about retaliation and ongoing harm, particularly when there's children involved in the case, often lead us to think really hard about trying to get into Albuquerque and Santa Fe and what that looks like. So the public education department being in Santa Fe is very helpful for that purpose. And sometimes we think it brings a little bit of distance that is needed for just all the parties to kind of breathe and hopefully let things settle so that we are not concerned about ongoing harm and injunctive relief related to that and what that would look like.
And I know in the damages claims what Alex was talking about, you might bring a section 1983 because of the cap. Do you tend to bring section or federal claims as well, or mainly are they out of New Mexico civil rights act?
We are almost always leading with state court claims, but pleading in the alternative, federal statutes, and then we are often getting removed by sophisticated defendants. It's not all defendants, but I would say sophisticated defendants for many reasons often prefer being in federal court.
And are you a sophisticated defendant?
I like to think so. I mean, with few exceptions, we will remove a case if it has something in it that makes it removable. We will remove it to federal court.
So what is the practical effect of this? If a case gets removed to federal court and you have a New Mexico, first of all, are the federal judges keeping the Civil Rights Act claims? Because, right, it says they are to be filed in New Mexico District Court. Or are they dismissing those out without prejudice to get refiled in the state court? Has that happened to anybody?
I've had it happen both ways. So I've had them exercise supplemental jurisdiction to also dismiss the Civil Rights Act claims after they dismiss the federal claims. But I've also had them say, okay, we're done with the federal case, kick it back down to state court. So I think it's going to be like it sort of always has been, where some judges are just more likely to want to exercise supplemental jurisdiction, and some are not.
I haven't experienced it yet. I haven't had one where I filed it with both.
And ours have not been bifurcated yet.
And well, not you, you would not have a concern about this, but does anybody have any concerns about the federal courts interpreting the Mexico Constitution?
Yeah, definitely.
Well, because you're making the choice, right, to bring a federal claim, the case gets removed, and if the federal court is not going to send it back, that's going to be the person determining or analyzing the state constitution. Right?
I mean, I think if you have a case that is definitely going to be in excess of the $2 million cap, then you might not have much of a choice. You're gonna have to be in federal court. And you're gonna wanna have that. And then there may be, and then in cases that are under that cap, you may wanna, it also may be that you make a judgment call that you think your federal claims are very strong. And you don't think that you're going to get booted out of qualified immunity because the law is very good for you. And in that situation, you may want to be in federal court where you have judges who are very used to dealing with civil rights claims. So if that's your situation, you may want to be there if you feel very strong about your ability to survive qualified immunity. Then it may be a good place to be. But if you are doing something new under the New Mexico Civil Rights Act and you want some kind of departure or some sort of different standard than you would get in federal court, then I think you would want to be in state court for that, to make that law. And I think it's important that that law develop. But I think it definitely depends on the case.
I would agree with you, Alex, and I think what I would add is that in addition to, I think, New Mexico state courts being more comfortable with potentially an extension of the law, working with a new definition like we have with gender under this act, I would add that I hear all the time from our clients how scared and concerned they are to have a judiciary that knows nothing of their life experiences, that has never been poor or a person of color or gender nonconforming, and what that feels like to be in federal court with those circumstances. New Mexico has done a ton of judicial education on working with low-income folks and working with people who traditionally have not had access to justice. We have not seen that same level of permeation with the federal courts. And so a lot of our clients are really scared about how their basic humanity is going to be treated. Am I going to be able to use my correct pronouns, my correct name, and what does that look like? Are they going to be recognized against me? And so we spend a lot of time thinking about how that experience is going to happen for a client, because civil rights cases, I'm sure my colleagues would agree, are very long-term cases.
So in that regard though, isn't it more important to you than to stay in state court and have the state constitutional law developed with respect to these rights that are recognized probably more broadly, in whether it's enshrined in other statutes or as a matter of policy, than to even include a federal claim and have it either dismissed or not given, a full robust treatment?
Yeah, that's a really good point. Sometimes we haven't included the federal claims for exactly that reason. And I think I would also say that we are not sure where this is going. We've had this such a short period of time in New Mexico that although I'd love to say our crystal balls are really accurate, I know they're not. And I think unless and until we start to get some cases that proceed all the way to trial and judgment and get some published case law, it's very hard for all of us to find out, are we being too risk averse or are we being too risky with our cases?
And have you had both state and federal claims in federal court? What's your experience?
Yes. Typically, the cases I have right now are either a 1983 with a concurrent Civil Rights Act claim or Civil Rights Act and Tort Claims Act together. And so, I wouldn't say it is what it is. We can't do anything about it if it's in state court, pled under the Tort Claims Act and the Civil Rights Act context. But I will say that from my perspective, state district court judges are so busy and have so few resources. They don't have an army of law clerks like the federal judges do to go do all this research for them and give them bench briefs and sort of all this stuff. Many of them did not do this before they went on the bench. They were not civil rights practitioners. If they learned about it, it was in law school. And that may be the last time they heard about the Fourth Amendment or the Eighth Amendment or any constitutional principles. And so they are not particularly experienced in analyzing those claims. And so that is on us as the practitioner to get that framework out there and get it out there in a way that we obviously benefits our client, but that we think correctly reflects the law so that we can start to get, like Michelle was talking about, let's get some cases, let's get some decisions, let's figure out how we're going to approach this, which benefits everybody.
And so it's true that federal judges have a lot of experience with civil rights cases, right? It's a huge part of their civil docket. And as probably fair to say that of the 97 district court judges and 15 appellate judges, there's not much experience.
It's
in
like
civil
Mark
rights.
Sandridge and no one else.
And no one else. So there are, I mean, it's a reality. So as practitioners, I think one of the panelists earlier had talked about it's practitioners' responsibility to educate the judiciary and the judges. How do you go about doing that? You know, when I think about the criminal context and when the interstitial approach came in, Justice Lawson basically said, all you have to do is mention the state constitution and that's good enough. Would any of you go into court just saying, I'm raising
The right to happiness.
the right to happiness and hope that the judge gets it right? What do you do?
I would say that you want to, I think in these kinds of cases under the Civil Rights Act, particularly because it's so new and until the law develops, you want to be very careful about really walking somebody through. I think you want to be very thorough, and I think you want to explain it very well and explain what the law is. And I think because we have the interstitial approach, which I agree with the earlier speakers, it would be good if that was not the approach. But because it is, I think you literally have to walk them through too, because under the interstitial approach in New Mexico, you have to show that if it is a right, New Mexico constitutional right that has a federal analog, you first have to show that you have to see whether the federal analog would protect that right as it is. That's the first step in the interstitial analysis. So if you have some sort of excessive force or anything where there's a federal analog, then you're going to be in that land anyway. So you're going to have to explain very clearly what the federal law is to say, and mine does or does not fall under that for whatever reason. And so no matter what, I think you're going to have to do that education. But even if that interstitial approach was not there, you would still want to do that until we have a more developed body of law that is more clear. So I think that you're going to want to walk through that. And I think even if we didn't have the interstitial approach, you're still going to be pulling, until there's a much more developed body of law in New Mexico law, you're still going to be pulling from federal law quite a bit. You might be saying, just like you would in maybe a tort or a contract or any other case where there's, you might be looking at other cases around the country and saying, oh, look at this, look at this, look at this, and you should agree with this one but not this one or whatever. And that just like you do in any other case. And so you would do that if there wasn't an interstitial approach anyway, but with that you also have to go the extra step of explaining why your right does or doesn't fit under that.
So what, go ahead.
I was just going to say, perhaps a word of caution. I've heard we have a lot of practitioners in the room. Other states have not adopted the extent of the New Mexico Civil Rights Act, and we're clearly a minority jurisdiction at the moment in how expansive this is, particularly against public officials and public accommodations. What we do in New Mexico is going to have echoes far beyond our state. And so to the extent that I think we have a tiny platform here today, what I would advocate for is for people to go beyond thoroughness, to think about the strategic plan that I think must exist for the development of our law in New Mexico, because what we do here will absolutely have an effect on probably all of the states in the United States. How we litigate these cases, the type of verdicts that we get, the claims that we bring, whether they're considered to be frivolous, if they increase insurance, all of these things that normally we do not have to consider under a state constitutional plan.
Boy, I hope you get the word out. Those are not the cases I'm seeing, by the way, the carefully thought out, well pled. Okay. I've got 2 tiers of cases, but I would say the 2-tier people probably need to get that memo.
So with respect to the interstitial approach, do you think that there's any room to argue that it shouldn't, that from the ground, from the district court level, that it should not be applied? Because although it's been applied fairly consistently in criminal cases, the interstitial approach in reality has never been applied in a civil case in New Mexico by our Supreme Court. So is there any room to just argue, our courts never really use the interstitial approach in civil cases, so let's not use it here? Or do you think that a district court judge is going to feel compelled to follow what the Supreme Court said in Gomez?
We've certainly argued in courts that, if an approach has been abandoned and the framework is not being utilized, and/or we have definitions that never existed under federal law, the way that we do. I was speaking to the Human Rights Bureau earlier this week about the gender definition that was recently passed in the last legislative session. Nowhere else in the country do we have a definition of gender that is the same that we are using for Human Rights Bureau cases in New Mexico. Why would we look at a federal analog when our definition is different?
I don't disagree with that. I don't think that's going to come up much under the New Mexico Constitution because we don't, other than the provisions about the Treaty of Water and we don't have anything that's like super unique in terms of the New Mexico Constitution. But this is not our first rodeo with this. We have a state law called the New Mexico Whistleblower Protection Act that is also pretty new. And when that was passed, there was sort of this same like outrage about no one's going to be able to hire anyone and we're all going to go broke and what are we going to do? And that really hasn't come to pass. There are a boatload of WPA claims that get filed all the time, and some of them are meritorious and some of them are not. But we looked at, there's a federal Whistleblower Protection Act, other states that we model our legislation off of. I think Colorado is going to be a good source of, or at least people are going to look to Colorado to see what they're doing with their Civil Rights Act. And then plus we have all this federal precedent. So those are kind of the things that I would go in with if I was, when I go start talking to state district court judges in my arguments and saying, we don't, you're not writing on a blank slate, and B, you don't have to. Look at all this guidance that's available for you to look at.
I think it would, again, depend on the case, but if I had a case where the state has not already, the state courts have not already departed, or there isn't a federal analog, I would feel hard pressed not to argue the interstitial approach. I think that you kind of have to. But, I mean, I like the argument, and you might make it, but I would feel like you kind of have to do it until they expressly say you don't have to do this anymore. But maybe I'm wrong, and people might disagree. But there also, though, are things that you can bring that don't have an analog or the state law has already departed. For example, our First Amendment analog, our state has already said that we have broader protections under that. Our Fourth Amendment analog, our state has already said we have broader protections than that. We have the Equal Rights Amendment, that does not exist in federal law. You do not have to worry about it, or you should say that the interstitial approach does not apply there because this is a different clause. So for those sorts of things, no, you shouldn't have to do any sort of interstitial approach. But personally, I would have a hard time. I would probably say, I'd probably do both. I'd probably say, you shouldn't have to pay attention to this because you abandoned it. But if you do, here we are, and we should win.
And there aren't a lot of cases under the Civil Rights Act, but there's a fairly robust body of criminal law in New Mexico dealing with these various, especially like Fourth Amendment protections and those areas that, I use those in my qualified immunity work sometimes to say, well, this is how the New Mexico Supreme Court has viewed search and seizure or a particular contour of that. So I think that will stay the same. Sometimes it's useful to go to that criminal law where they've analyzed this and use that as well.
Michelle and I were talking earlier that we tend not to do police work because there's plenty of you out there that are doing it a lot. And so it doesn't come up as much. These tend to be more novel areas and broader other areas of the Constitution that are being violated.
Yep. And I was out telling everyone before, when the debate was happening on the Civil Rights Act, that I thought the primary target was the schools. And everybody was saying, no, it's the police, Cody, it's the police. And I said, I don't think so. I think it's the schools. And I stand by that. Because schools do a lot of things wrong. No, they screw stuff up. They just do. They have a ton of employees. They have a difficult setting. They have all these record-keeping requirements. They answer to all these different masters. Teaching is an impossibly difficult job under the best of circumstances, which we do not have in New Mexico. Our state has never historically allocated the resources that it needs to, up into and including now, where we have record budget surpluses. We still don't devote the resources to education that we need to and should have. So, in the context of all of that, asking these people to be perfect from a liability standpoint is ridiculous. But that's the standard we have. And so knowing all of that, my immediate thought was they're gonna go after the schools. Because you can always find something that someone did wrong.
Yeah.
Well, if I can maybe chime in on that, it also seems to me very clear that at least in the last 2 election cycles, schools have been a flashpoint of culture politics. And so the existence of schools as this like petri dish where we know that there will be overreach and there might be problems that involve constitutional elements and Title IX officers that are not lawyers and people who are not law trained making policy decisions and having decisions that affect a huge number of students. It seems very predictable to me that if you have all of this public information on police officers and headlines across the country, that the fact that schools were also, I think, being put forward as this place where the public is having these debates in a very open way, obviously then there will be litigation there. And unlike Colorado, we don't have another state that we can easily point to and say, well, here's how another state is handling these public accommodation and public official type cases. It's on us.
How's your education of the judges gone so far?
It is a mixed bag. I have walked into some courtrooms and started talking about the interstitial approach, and the judge is like, gesundheit. And like, and I'm gonna back it up and give my other presentation where I started to start. Some judges are just more conversant in those areas. Like there are state district court judges who are familiar with how this works, maybe because they have a strong criminal background. So they're a little more familiar with certain aspects of the New Mexico Constitution. Which, to be fair, when the debate on this was happening, I had to pull out a copy of the New Mexico Constitution because my only interaction with it was to write a motion to dismiss when someone would try to file a constitutional claim under the Tort Claims Act. And I had the same motion to dismiss that I've been filing for 17 years. And so I hadn't actually read it in a long time. And I was like, I better brush up on this. So it's my job to educate the court. If the judge doesn't know what the interstitial approach is, or why that's being applied, or why we're suggesting that that's what should be applied, or why these are the cases that I think should control these issues, that's my job. That's why I get paid the big bucks, is to convince the court my way is the right way.
I think as a plaintiff's attorney, it's harder because you're trying to, it's very comforting, I think, for, if you are a judge, many judges are very knowledgeable about these things, but for those who maybe have not, have not brushed up on civil rights recently, it's comforting to have federal law that you can look at and rely on, and there's a huge body of it, right? So that can be very comforting. So I think that as a plaintiff, you have a more uphill battle because what you need to do is say, if you're trying to get them to do something different, is to say, no, ignore all that, do this instead. And you would need to really explain why. And that involves, I think, an analysis of all the federal law that Cody's gonna bring and say to us. You're gonna really have to explain why that's a bad idea, and that may be going outside the box to really look at the criticisms of those that are not just in cases, but are also maybe in law review articles, or maybe in treatises, or in other ways, and also trying to get those perspectives. And I think when these cases, when we start making more and more law on this, and these cases it's still a relatively new law, so I don't know how much there hasn't been a whole lot out of the Court of Appeals and the Supreme Court on this yet, but once those things, once those cases are there, I think we want to also be mindful about having amicus briefs and things like that are going to be helpful to educating the courts to make this law, particularly when you're asking them to do something new.
Agreed. And one of the things that I think this was something that Professor Schwartz was commenting on, New Mexico has these cases have a 3-year statute of limitations. It's up in July. I don't want to accuse any of my brethren on the other side of waiting until the last minute to file their claims, but it's not uncommon for claims to get filed right before the statute of limitations runs. So I think we're not there yet in terms of what the full caseload is going to be. There are going to be more and more of these that are coming along as kind of time passes. You're not going to get them up on interlocutory appeals. You're not going to get interlocutory review of any of these claims. I wholeheartedly agree with Luis Robles this morning, saying that in the old days, and when I started practicing was before a Supreme Court case called Pearson versus Callahan that came out in 2009 or 10, and it basically said, okay, you've got this qualified immunity analysis, which in the old days had to be done in the order of constitutional right violation, then does it violate clearly established law? And we never won on the first part, so we just tried all the cases. And it always came down to were the officer's actions reasonable. I mean, that's what the trial was about. Well, Pearson versus Callahan said you guys can take that in either order. If it didn't violate clearly established law, you don't even have to do the constitutional analysis. And when that happened, that changed everything. Then all of a sudden it became, and I'm a mediocre legal writer, so that really hurt my heart, because now instead of taking depositions and getting cases ready for trial, we're writing briefs, and that's all we're doing. We're doing interlocutory appeals to the 10th Circuit, and we're doing that. But I think this is going to be back to that original thing, where we're going to have to try some of these cases. We're going to have to take them up on appeal. We're going to have to make a law to figure out exactly what the framework is. And that takes a long time.
Well, that's my question too. I mean, we are talking about the New Mexico Civil Rights Act, and we are talking about the particular provisions of the New Mexico Constitution. We've been spending a lot of time talking about federal law, but what we want to develop is our own state constitution and the rights under the various provisions of our Constitution. So how do you go about arguing? You said you have to argue interstitial, but also breaking away from that from the very beginning. I always worry about preservation issues, because at the last Appellate Institute, all of the appellate judges said, oh yeah, you didn't preserve it, we're kicking you out, you're kicking you to the curb. So how do you move the conversation forward about the state constitution and get it to the Supreme Court so that decisions can be made?
I think,
$1 million question. Yeah, please.
I would think that you'd want to put, I mean, there is that recent case, the name is eluding me right now, so hopefully you know, but there was a recent case that was mentioned earlier today too, where the court did say, we're thinking about
the election case.
We're basically thinking that maybe the interstitial approach isn't that great, and we welcome your thoughts on this. So I do think that has certainly opened the door, and I would think to preserve that sort of thought, what you'd want to do is say from the get-go in the lower court, this is something that we think should, you'd want to say, we don't think this should apply right away, so that you preserve it and you know that argument's coming. You might say, you may have to make this, you may feel like we need to make this argument here, and we'll do it, but we do think that this should not apply. And just so that, I would put that in all of the briefing that we do to try to preserve that. But, I think till then, that would be the way you'd have to do. But I do think it's really important that we try to develop New Mexico law, which is one of the reasons I think the interstitial approach should go, because with that, it gives you a lot less opportunity if you're always going to say, well, does this just kind of fall under what the feds would do? You're never developing new law. It's sort of like qualified immunity. You get stuck in that loop of, you never get to show what the new constitutional violations are. You want to have that development. So I think that is really important for us as plaintiffs attorneys to be developing that law and showing what those rights are going to look like. But I think we also have to realize that that's going to take time. And so I think with clients in particular, you may have to tell your clients you're in for a long haul. This might be something that takes all the way up through appeal, potentially all the way to the New Mexico Supreme Court before we really get there. And that might be the reality. However, your alternative in federal court was to sit around and have qualified immunity and then go up to the 10th before, and then have it come back down and maybe go up again and on the next qualified immunity motion. So they were in for a long haul too. So we're all in for a long haul no matter what on constitutional rights cases. But I think for now, while this law gets developed, we've got to be willing to tell our clients that it might take a while.
I was just going to chime in to say that it seems to me like in all jurisdictions, but I would hope here in New Mexico as well, that there can be some conversation that happens between practitioners, who are advocating for their clients, and this is what we believe the law should be interpreted, the court saying we're calling the shots and balls, and academics who are telling us this is what the law could be. And I believe if we in New Mexico, and particularly those of us that do any kind of academic publishing, are serious about developing this area of law, we should be looking through the Constitution about what is unique here in New Mexico. We should be considering how that conversation between practitioners and the courts and academia can enrich what I think is really fertile ground for this to develop. And I think this is the prime audience of what I hope are people who care about the development of this area of law. Because right now, we don't have the crystal balls. You know, none of us sitting on this panel, despite all of the years of experience up here, have a good idea about where all the boundaries are here. And we won't, possibly for, I don't know, 8 to 10 years, maybe. And that's a hard place for us to litigate cases. It's a hard place for us to have insurance. Yeah, it's a hard world. And I think if we're gonna make it any better, it behooves us as a profession to care about how the laws develop instead of being passive bystanders here.
And that is, the concern on our side, on the defense side, is, okay, if the interstitial approach doesn't apply to a particular issue, and there's no New Mexico case law to guide us in the criminal context, so then what is it? Because skilled plaintiffs counsel are gonna argue it's negligence, it's basically negligence. It's an act or omission, and did it take away your right? It can't be that. I mean, Speaker Egoff confirmed that we were right, that it's not a negligence-based standard. So then what is it? And I think that's kind of the place where we're at right now, is all we've got right now are competing arguments, and it's gonna take some rulings and some decisions to give anybody clarity. And we want clarity too, because if we have clarity that we know we're gonna lose every single time on an issue, we're gonna settle those cases. But we can't, right now, we're going to our clients and they're saying, we'll fight everything. And it's like, okay, I mean, we will until we don't.
But as long as we keep using the interstitial approach, we're going to expose, right, we're going to have a Michigan versus Long problem. Any case that gets decided by our courts could potentially be decided by the United States Supreme Court, which is not doing a great job for civil rights these days. And the only way to keep state court decisions in state court under our Constitution is to do it on adequate and independent state grounds. So what is the fastest way to get there? And how do you convince your clients to stay in for the long game?
It's a great question. I mean, I think that for our clients, as I mentioned earlier, we're often not concerned so much with the monetary award. And as legal aid, you know, we don't have to have an eat what you kill approach to how we're bringing in fees. Instead, we're much more concerned with how that landscape is changing in terms of independent rights. And what we tell our clients is that if you were serious about changing things for people who come after you and are similarly situated, you might be looking at 8 to 10 years. But the end result, we hope, is that some of those irons that we're putting into the fire do yield results. We don't know what they're going to be, but we think that the law will develop and it'll happen, you know, within a decade.
Here's my little secret advice. When you get to the Court of Appeals, ask them to certify the question to the Supreme Court, since they've already invited you for the change.
Fair enough.
And I think it was either Matt or Julie this morning, and one of you just mentioned the need for amicus briefs. And I think it was Julie that said, this is a lot of work, right, to do this. So are you thinking about this all the time when you do civil rights, or, civil freedom cases under the Civil Rights Act? Like, what is the constitutional provision at issue? How might it be different? And who could I get in to be a potential amicus on this?
Yeah, I mean, I think that, I really see this act as precious, so I think hard about the cases that I'm going to bring under this act to make sure not to screw it up. So I'm not going to bring a real lame claim or a real lame person. You know, if it's something that I think can make very bad law, that might not be the best place for this right now. Especially if you're looking for some new standard or something different. So I think, that's my view, and maybe other people, you know, and that has its ups and downs, because you also have real clients that need real claims. But maybe they have a different claim that you could bring if this one doesn't seem right for the New Mexico Civil Rights Act, where you might make some very bad law. Maybe you bring your tort claims back instead, or you bring it in federal court where, you know, if you think you've got a claim there, because, you know, then because it's bad anyway, right? Like, or, you know, you're doing what you're doing. And yes, you need to make sure that you're doing the best for your clients. But part of that is also doing the best for developing this law in New Mexico and making sure that you can make a better landscape. So yeah, I think, you should always be thinking about really hard about what are your claims, where could this be better, where could this be different, what standard are you looking for that would be different from what you would get under the U.S. Constitution. Is this a good claim for this, and also who would be supportive of this, and what resources are out there, what scholarship is out there on this, what groups might be particularly interested in this issue that would really want to weigh in, for good for you, and also who are bad for you, so you know what you're going to be going up against, because the other side's going to do the same thing. And so I think that you very much want, it's going to be a debate. I mean, I do a lot of prison work, I do a lot of jail work. Those are issues where you're going to and you're going to have a lot of pushback, and you have to just make sure that on these battles where you're looking for maybe a different standard, you want to make sure that you've got your ducks in a row.
I think I would actually go a step further, and I would say if you find an iota of value in New Mexico's Civil Rights Act, you cannot engage in the spaghetti bowl lawyering where you throw everything at the wall and see what sticks, because you will make that up.
Let's open this up for questions. We can go, my new hand will go up. Did you want to clarify, don't screw up to something else?
Yeah.
I thought you might, yeah.
I'm still not going to use the actual word.
Okay.
So, I have a big enough mouth, I really do.
It's so the camera can
All right. I want to piggyback on what Alex was saying, because I think she's spot on. And I think in this recent elections case, they did talk for the first time really about interstitial analysis. And if you look at footnote 7, they outright say, we agree that Gomez does not bind this court as to our analysis of state constitutional questions, and we encourage thoughtful and reasoned argument in the future addressing whether the interstitial approach is the proper method to ensure that people in New Mexico the protections promised by the Constitution. And this is last month. And for that reason, I think we have to say, not only should interstitial analysis not apply, we have to give them good arguments and reasons why not. And then I agree with Alex saying, but if you're going to apply it, we win anyway, but we've got to say more than it doesn't apply. We've got to say why. And I think we all need to share with each other what the various arguments are in order to help expand and espouse this policy, or it will apply by default. So, my 2 cents.
Thank you. Aaron?
I wanted to ask if you all could touch on any recommendations for approaching claims being brought under the Inherent Rights Clause, which was mentioned earlier. That's Article 2, Section 4, I believe. And I think it is one of those sections of the New Mexico Constitution that does not have a, distinct federal analog. And you kind of laughed off, oh, it just says, you have the right to happiness. What does that mean? And I do agree that it is kind of wishy-washy, and in the case law where Tort Claims Acts were trying to get constitutional claims in there, courts absolutely did not want to deal with the Inherent Rights Clause historically. But it is kind of the elephant in the room now because it exists, and it exists in the Bill of Rights, and now we have the procedural vehicle to pursue claims under that. So I guess from the defense side, how are you looking at these claims as actionable, if at all? And from the plaintiff side, how are you thinking about getting around, the sort of nebulous, wishy-washy nature and the fact that there isn't developed case law for this specific clause?
So the way I've dealt with it, because I would say at this point, I mean, I literally still have 2 cases where it's in an employment context, and they're just basically ignoring the explicit language in the statute of the recent Court of Appeals decision that says you can't bring this claim and they don't care. And so I would say the majority of the claims I have that are not paired with a 42 USC 1983 claim are inherent rights. And there is no federal analog. There's inalienable rights, but they're in the due process context, right? And so what I've tried to do is put it in a different box. And to say, Judge, they're telling you that this is about their right to happiness being violated, but what they're really pleading is an employment claim. Or what they're really pleading is a due process claim because they lost something that they're claiming the process was inadequate that was given to them before that deprivation. Or it's a substantive due process claim that they're couching as an inalienable rights claim. So what I've been doing with those is putting them in a different box. Because at this point, you're exactly right, it is in the Bill of Rights, and there's not a carve-out in the Civil Rights Act for inalienable rights. Whether there should have been or not is a whole different debate. But I don't think it's enough to just say, oh, Judge, these claims are ridiculous. I don't think that's gonna get you anywhere. So I think you have to frame it differently, and in a way that you can then make a coherent legal analysis as to why that claim fails.
And I agree with what Cody said. I think you just need to be careful about the type of claim you bring. Our Supreme Court more recently has equated it with a sort of preamble language, which it is not. It is a standalone provision of our Constitution and should be given effect. We have only one case, and it's a pretty old case, that actually used safety and happiness to refuse to, I don't understand criminal law, but to refuse to send a prisoner back to Kansas because the court knew that this prisoner was going to be mistreated in the prisons in Kansas. And under the safety and happiness clause, kept him in New Mexico. So I think you just have to be careful about the claims that you bring. Yeah. Oh, one more question? Oh, sorry.
Hi. So at the U.S. Supreme Court, we've seen a recent clash between the Supreme Court's First Amendment jurisprudence and then increased state protections for LGBTQ plus people. So my question is, are we seeing a similar clash already here in New Mexico, and do you have strategies for avoiding that clash?
I think it is very clear that under the current makeup of the court, there will be a rollback of many individual protections. I think that's clearly outlined in Dobbs, and I think the court, much like someone mentioned, footnote 7 is telling us here's where an invitation is. The U.S. Supreme Court is making similar invitations to all kinds of plaintiffs. I think in the First Amendment context, what I believe is most likely to be successful are some cases that are coming out of the Fifth Circuit related to religious liberty. And do I think that we're going to see a religious liberty First Amendment set up here in New Mexico? Maybe not. But I know for a fact that people are talking about litigating book bans. And so I think that in New Mexico, we may still see development of our own First Amendment jurisprudence, which I think Alex pointed out has reviewed more expansively. We clearly have that in New Mexico that's different from our federal counterparts. I don't think it's going to play out in a religious context the way that it will in the U.S. Supreme Court, but my esteemed colleagues might disagree.
Well, that expansion came in the pornography context, so I don't know that we'll be banning books that quickly.